Dear viewers, welcome to our presentation, Thomas Valva, Child Abuse, Custody, and the Legal System. I am Dr. Roy Aranda, clinical and forensic psychologist in private practice and adjunct faculty at John Jay College of Criminal Justice, where I teach 2 courses in forensic psychology. I'm also a past president of New York State Psychological Association and twice served as president of the forensic division of New York State Psychological Association. In this presentation, in which I am joined by psychologist experts, Doctors Neil Grossman and Robin Lynch, who I will introduce momentarily, we will discuss at length several aspects of the tragic life and death of a little special needs boy, Thomas Valva, who died at the age of 8 on January 17, 2020, after sleeping in the unheated garage of their Center Mauritius home. I'd like to introduce my assistant and hostess, Nasalin Peralta. So, Nasalin, why don't you please introduce yourself?
Hi, good evening. It's lovely to be here with you all. My name is Natalie Peralta. I am a forensic psychology student at John Jay College of Criminal Justice, currently studying at the master's level. And I'm here to, excuse me, assist and help out in any way that I can this evening. And I'm glad to be here. Thank you for having me.
Well, Naslin, on a more personal note, I wasn't going to let you get away with just such a brief introduction. I'd like to mention that she was my teaching assistant in my forensic psychology class at John Jay 2 years ago. She was so exceptional that she set the bar very high in terms of what to expect from future TAs. So she also has participated in some presentations with me and will participate in a forthcoming presentation pertaining to the impact of modern terrorist events that the world has been ravaged by recently. Natsalin also wrote a magnificent paper that won her the Roy Aranda Social Justice Award at New York State Psychological Association in 2022. Thank you for helping out today, Natsalin. Now I'll introduce our presenters. Dr. Grossman will talk about the dynamics of the legal process. Dr. Grossman has conducted many child custody evaluations. In addition to his clinical practice, he is active in collaborative divorce and as a parent coordinator. Dr. Grossman currently chairs the Psychology and Law Committee at Suffolk County Psychological Association. In the past, he was president of the Forensic Division, New York State Psychological Association, and the Family Forensic Task Force of the American Psychological Association Division of Family Psychology. Dr. Grossman has been appointed to the collaboration project of APA and ABA. He was president of the Academy of Family Psychology and the Council of Specialties in Professional Psychology, and a vice president of the Division of Family Psychology. He was a board member of the American Board Family Psychology, ABPP. So, welcome, Dr. Grossman. And on a personal note, I wanted to share that I've known Neil for about 2 decades and have been privileged to participate with him in many conferences at Suffolk County Psychological Association and New York State Psychological Association. We have both been members of New York State Psychological Association's Forensic Division, and I am a member of the Psychology and the Law Committee that he chairs at Suffolk County Psychological Association. Dr. Grossman also was a presenter at one of my forensic psychology classes at John Jay College of Criminal Justice. Welcome, Dr. Grossman. Is there anything else you'd care to add?
It sounds very complete. Thank you.
Okay, thank you. And I take the liberty of calling you Neil. It seems way too artificial for me to say Dr. Grossman when I'm talking to you on a more personal level. Now allow me to introduce Robin Lynch. Dr. Lynch will talk about the dynamics of child abuse. Dr. Robin Lynch is a graduate of Columbia University Teachers College EDM program in counseling psychology and Columbia University's PhD program in social psychology. At Teachers College, Columbia University, she interned for 5 years at the Morton Deutsch International Center for Cooperation and Conflict Resolution. For more than 20 years, she has been on the appellate division, first and second department panel of expert witnesses specializing in child custody cases. Additionally, for 15 years, Dr. Lynch chaired the Child Custody Evaluation Committee of the Forensic Division of the New York State Psychological Association. In that capacity, Dr. Lynch ran trainings for 15 years that included nationally distinguished child custody specialists such as Leslie Draws, PhD, and David Martindale, PhD. Dr. Lynch is published in the Journal of Child Custody and the Family and Interpersonal Violence Quarterly, and she is an affiliate of George Mason University's Mary Hodge Center for Reconciliation. Her public service website, Conflict Uncomplicated, introduces the concept of Type 3 conflict, which is the subject of a Think Peace podcast. Dr. Lynch sat on Governor Hochul's Blue Ribbon Commission on Forensic Evaluations, where she co-chaired its training and certification committee, and she was a member of the working group that created the training legislation that this year passed both houses of the New York State Legislature. On a more personal note, I've known Robin also for approximately 2 decades, and we have made numerous presentations together. We both have been involved in New York State Psychological Association's Forensic Division. Robin also made presentations to my classes at John Jay College of Criminal Justice and was involved in a mock family court trial presentation with me and 2 attorneys as well. Welcome, Dr. Lynch. Is there anything else you'd care to add?
Sorry, Dr. Lynch, we were unable to hear you.
Roy, thank you very much. That was very complete, and it's a pleasure to be here.
Well, thank you both. Now I'd like to begin. Dr. Grossman, please proceed with your presentation.
Okay. I'm going to talk about what we know about the Valva case and also the dynamics of the legal process. Our understanding of the court process in the Valva case comes from reports by Newsday. We don't know what precisely unfolded because we're not using the court records that are unavailable, because they're unavailable. So we're going to be talking about these issues in general. The Newsday article tells us that the mother made child abuse allegations about the father to the court. The police did not support these allegations, and therefore they were regarded as false. Courts in Long Island have generally taken a negative view when unsupported child abuse allegations are made. The mother also did not cooperate with the attorney for the child. Additionally, the parents did not take steps necessary for a forensic evaluation that was ordered by the judge to begin. It seems like, in general, the mother was viewed as uncooperative. In situations where a parent is uncooperative, the courts have few options available. They can place that parent in jail, or they can reverse custody, giving custody to the other parent. In this case, the case of the Valva boy, the court reversed custody and awarded custody of the children to the father. Additionally, they restricted the contact between the mother and the children. From experience with the courts, I'm assuming that this latest step of restricting contact was taken to assist the children in making the transition from living with the mother to living with the father. However, within a few months, the court arranged for the mother to have contact with the children. So this total restriction did not last after a month or two. Okay, let's now talk about the dynamics of the legal process. And we're talking in general. And at the end of this, we're going to look at how a forensic evaluation might have helped in the Valva case. I'm going to be talking about divorce in the court, an overview of the adversarial process in custody proceedings, the use of an attorney for the child, an attorney that represents the child or children, child custody evaluation, also known as forensic evaluations. And then, as I had just said, we'll look at how a forensic evaluation may have helped in the Valva case. Okay, so to start, looking at divorce in the courts. All divorce settlements must be approved by the court. Three main ways of reaching a divorce settlement are litigation, mediation, and collaborative divorce. In litigation, people file for a divorce and retain attorneys to represent them in the process. There's then a series of court conferences where the court reviews the couple's progress towards a settlement. In between these court conferences, the couple, through their attorneys, attempt to agree on the terms of the divorce. And sometimes the interests of the children are represented by an attorney for the child. I'm now going to discuss an overview of the adversarial process. And that's the process that's used in court. Attorneys represent their client's side of the dispute. Each attorney makes motions to the court to advance their client's interests. Since each attorney is trying to advance their own client's interests, this process becomes adversarial. If the couple, through their attorneys, fail to reach an agreement, the dispute goes to trial. In a trial, arguments and counter-arguments are presented to the judge. Witnesses can be called by each side. One attorney presents witnesses that support the case for his or her client, and then cross-examine and tries to discredit the witnesses for the other spouse. It is assumed that through this process, the examiner of the facts, the judge, will determine the facts in the case and make a decision. An artifact of this process is that it can increase the animosity of the divorcing couple. Now let's look at the attorney for the child, also known as the AFC. Courts had used a different process. They had used a law guardian to represent the child's interest. The law guardian was supposed to take a neutral stance and represent the best interests of the child. This was changed on a national level because it was believed that an attorney who worked as a law guardian developed a relationship with the judge, and then that was gave that attorney an unfair advantage when the attorney represented a parent in a different case that was before the judge. To correct this, it was recommended that the AFCs be used instead of law guardians. However, this change had unintended consequences. The AFC is supposed to represent his or her client's wishes. Only in extreme situations is the AFC supposed to go against their client's, the child's, wishes. So problems occur. First, the child may not be mature enough to make decisions about who he or she should live with. Secondly, the process opens up or encourages the parents to attempt to manipulate the child regarding which parent the child wants to live with. More important for this presentation is that when the AFC and the attorney for one of the parents are in agreement and against the attorney for the other parent, this can have a powerful effect on the judge. Okay, now let's look at the forensic evaluation. What a forensic evaluation is and how it can help the court process. When the facts in a divorce are unclear, or when one spouse alleges that the other spouse is detrimental to the child, the judge can order a child custody evaluation, a forensic evaluation. This will be conducted by a neutral professional expert. The evaluation frequently focuses on the mental health of each spouse, the parenting capacities and skills, and the needs of the child. The evaluation is conducted for the judge. The judge then shares the evaluation with the attorneys. The attorneys can inform their clients about the content of the evaluation. A forensic child custody evaluation is usually comprehensive. It includes a history of each parent, personality testing of the parents, a description of each child and the needs of that child, the relationship between the child and each parent, parenting skills of the parents, the review of all relevant records, and interviews with people, professionals usually, who have collateral information about the family. Then there's an examination of all the information obtained and a search for consistencies and inconsistencies. From this, the forensic evaluator renders a report and gives that to the judge. The judge will typically not read the evaluation unless a case goes to trial, and the report is then entered into evidence. Now, sometimes I wonder what happens if the case doesn't go to trial and it's not rendered into evidence. Even then, the attorneys can use the contents of this report to inform their case. I wonder whether many attorneys fully use the information in the evaluation. In general, attorneys develop a theory of a case, and they use that to present evidence that supports their client. This is like telling a story that will present their client in the best light and the other spouse in a negative light. Thus, rather than developing a full understanding of the parents and the children, they cherry pick information to highlight and information to avoid. Hopefully, the judge develops a full understanding of the family and the individuals in the family before making decisions about the case. Judges are supposed to make their decision based on the information presented at trial. So information that's not presented on trial is not part of the judge's view. In some instances, a judge may ask a question about a witness during the trial, so the judge may get more information that the attorneys have decided to present. A potential problem is that attorneys may not know how to use information from a forensic evaluation. For example, what happens if the forensic evaluation finds that one of the parents is depressed? The attorney for the other parent might want to highlight the fact that this parent is depressed. But this might be done without an understanding of whether the depression is controlled by medication or whether the depression actually affects parenting ability, the parent's ability to parent the children. The attorney is looking for facts that support his client and discredits the other client. Okay, so now let's turn to what a forensic evaluation of the Valva family might have found. In such an evaluation, the personality of each of the parents and other adults who help take care of the children would be discussed. Additionally, the parenting ability and skills of the adults would be described, as well as observations of the actual parenting, that is, each parent with the children. Now, the personality part of the forensic evaluation does not necessarily indicate whether a parent is abusing a child. And in this particular case, that was a very important aspect since Thomas Valva died due to child abuse. However, the evaluation might show the degree to which a parent is self-centered versus having empathy of others, and also whether there was an acting out potential for either of the parents, either or both of the parents. The evaluation would discuss the strengths and weaknesses of the parents. However, again, this is not always helpful in the adversarial process. Information that is black and white, what supports or negates a client, is easier for the attorneys to use. Nuances can be lost. Thus, unless the evaluation clearly favors one parent, the evaluation may be less useful in the court process. Now, in this case, CPS did not have the finding that child abuse was occurring. In the forensic evaluation, collateral interviews would have highlighted the concerns of school personnel, concerns that the children would be abused. And this would have been very helpful. A side note about collateral interviews as part of a forensic evaluation. Some legal scholars would like to eliminate these since, from a pure legal sense, it brings secondhand information into the process. That is, the forensic evaluator will report and can testify to what people said rather than that secondhand, rather than having the people there to report directly to the court. While that's correct, I believe that the value of a good forensic evaluation using collateral interviews more than outweighs what is lost from a pure legal sense. A forensic evaluation provides a thorough review of the case, connecting various data and providing reliability and validity to this data. Thank you.
Well, thank you, Dr. Grossman, for that wonderful presentation. Now, Dr. Lynch, please proceed with your presentation.
Dr. Lynch, you're muted.
Thank you, Neil, for that presentation. That was great. These cases, such as the Valva case, where the court misses the abuse that's occurring, that resulted in the child's death, have quite a history in the court. And I'm going to back off a little bit and give a little context for child custody generally. Because it's only relatively recently, the last several decades, that the expert opinions, child custody evaluators, have become central to the custody conflicts in family court and Supreme Court. If you go back in time, you could say that there was no such thing as abuse in a family, as the father had complete control of his wife and the children. And corporal punishment and whatever else was inflicted was his right to do so. In time, in our society, the mother became central to raising the child. And we valued the mother as the most important person in a child's life. It was referred to as the tender years doctrine. So the father, initially in the history of our society, made decisions and treated the children and his wife as he pleased. In time, as values changed, mother assumed that role of raising the children. And then, there is a case, a few different cases are cited. One in New York State is Kessler, 1962, brought in the use of an expert to help the court determine custody. And in New York State, helped establish the best interest of the child standard. So we moved from the tender years doctrine to the best interest of the child standard. And the best interest of the child standard, while theoretically very well-intended, opened up a host of problems, because it's difficult to know in a custody conflict what is in a child's best interest. To get information is very hard. But it was with this shift in the courts that we opened up the role of the child custody evaluator. And we opened up the best interest of the child standard. And in opening that up, abuse of the child became central to the evaluation. In other words, no matter where you stood on the best methodology for conducting these evaluations, the safety of the child and that the child be free of abuse was paramount and should be central to the evaluation. So it is constantly something that the evaluator should be monitoring. However, this is where you get into the dynamics of what is going on in these cases. And if you look at it in this way, now, for example, only today I was talking to somebody from a totally different part of the state of New York who's been an evaluator there for decades, who described the nature of the cases that came to evaluators very differently than what we tend to see down here in the first and second departments. That's the more southern part of the state, southern and eastern part of the state. So I want to be sure to say, as I'm describing this, what we're looking to get at is the facts of what's actually happening. We get at the family dynamics, actually what is happening. The argument is made that as about 5 to 10%, and this is a statistics that's been quoted for many years, so it appears to be stood the test of time, of child custody conflicts actually end up needing an evaluation. In other words, the judge feels that a neutral evaluation must be ordered. Otherwise, the litigants, that is the two parties involved, usually the biological parents, but not necessarily, the two parties involved, can come to a decision about custody that's satisfactory to the court. But when they cannot decide, and again, this is something like at the most 10% of these cases, what we tend to see is at least one of the litigants is unable to compromise in any way. They're not able to work with the other parent. And what we call this is what we call in psychology, or we're apt to call, a dysregulated person. You'll hear the term emotional dysregulation, affect dysregulation. These cases are very difficult when there are these powerful psychological defenses and in at least one of the litigants that makes any kind of compromise possible. And this is where we get into abuse. This is where we have the dysregulated individuals often unable to self-regulate, project. That is, the emotions they're feeling internally, they're not able to manage. So they literally project them on to the other party, accusing the other party of what they are doing. So in fact, I think you're having an affair, one litigant will say to the other party, when in fact it is that very litigant who's having the affair. Another kind of behavior you'll see when you have these highly conflicted relationships. I I sort of regret using that term, highly conflicted. This is where you have at least one party who is projecting onto the other party. So another example can occur when one party pushes the other one on the floor, let's say, and says to that party, "What are you doing on the floor?" "Well, you just pushed me on the floor. I did not. Stop blaming me for everything. Learn to manage yourself." So the person who's projecting denies what they're doing and disassociates from what they're doing. This is what we believe is going on. Other examples that can occur in these cases where there's a dysregulated individual is one party will literally, in front of other people in a public area, such as a park, hit the other party badly, beat them up. The police are called, the police come running, and the person who's perpetrating the physical abuse will say to the police, "Oh, officer, glad you're here. Things got a little out of hand, very glad you're here." And the other party, who doesn't want to press charges, will say, "Everything's okay, officers, everything's okay." On a dime, the perpetrator, the abuser, can change affect that way. These are the kinds of dynamics that can occur when we've got abuse going on. Then you have what kinds of people are abusers. Abusers can pass mental health examinations with flying colors. They're very difficult to detect, and they can only be really seen, and their behavior really only made evident over a period of time. So you have these very difficult conflicts where, for the evaluator, unfamiliar with this kind of person who is afflicting this kind of damage, they may not, and are often bewildered by what is going on. A dysregulated person in this way, this type of dysregulation, I've coined the term narcissistic dysregulation, but this kind of person who is so dysregulated always believes they are the victim. And the result of that is that the true victim is apt to internalize those projections. They're apt to come to believe that they have done something wrong. They may believe they often believe they deserve the abuse that is being inflicted upon them. So you have a real reversal of roles. The victim feels responsible, and the perpetrator feels they're the victim. But additionally, this kind of projecting can affect really everybody who's involved. It creates a dynamic. People are forced to take sides. And the role that the perpetrator plays, their sense of themselves as being victimized, is something that many members of court can come to identify with. They feel such a victim that they're enraged, and those who are attached to them and support them become enraged as well. You see a level of anger in these cases that is very disturbing, that the evaluator may not have experienced before, and that may appear very threatening. So these are the kinds of dynamics that may be playing out between the two litigants, that the evaluator is expected to analyze and to pick up on, because it's very important in terms of the best interest of the child, because if one of the litigants is abusing the other parental figure, the children are absolutely at risk, not only for being traumatized by watching the abuse, but also because they may become abused themselves. They almost certainly will be, in time, become the abuser's victims. So this is a dynamic you really need to pick up on, but with the reversed roles, and this can be a very difficult thing to detect. And I will tell you, I certainly have had cases, especially when I was new to this work, where I would be so terrified of what turned out to be the more innocent party because of what the other party had said about them. Very convincing, very, very convincing, only to find the other party very concerned about the child or children in question having access to the other party, wanting a peaceful resolution that seemed to elude them, very responsible and attentive by all reports. So it's it's very hard to see what's going on. And to take a step back, abuse is generally very hard to detect. I would argue that it can only be detected over time. And yet this is really a tragedy because it does so much damage. Also, just so you know, abuse and domestic violence are now, the two terms are being used almost interchangeably, and an umbrella term for them is coercive control. Abuse is now really being called legally in some states, and in the literature, coercive control. And the point is that abuse can occur in many forms. Yes, there's physical abuse, and that tends to be what the court wants to see. Otherwise, they're suspect. That has been shown. But and tragically, sexual abuse, financial abuse, the most devastating, and there's good empirical research on this, is what they call emotional abuse, psychological abuse. Repeatedly telling the other person they're worthless, that it's their fault, in such a manner that the person loses any sense of themselves, any sense of their worthiness. They feel put down, dejected, mental health issues ensue, and there can be, you can have stress strokes out of this. I've worked for years with somebody with she's a paraplegic, as a result of a stress stroke in an emotionally abusive, there's no physical abuse of relationship. There's also no children involved in that. But this is what the court is expected to make sense of, and they're looking to the evaluator to assess this. Another thing that is important to know about abuse is that very often the victim and the family members, and sometimes the social workers, mental health professionals, and attorneys can become traumatized as a result of this dynamic that's playing out. It can be horrific. And it's as a result of that, traumatized people's behavior is often counterintuitive. And without, you can go on at length about this, but without belaboring it too much, a big question the court has and continues to have is, why didn't you leave? If the abuse in whatever its form was so bad, why didn't you leave? And there are many reasons for that, but very practical ones. You have no place to go, no money. You're worried about the children. You don't know how you're going to take the children. You don't have any support on the outside. Also, there's other things such as, and this is getting more attention, just heard a lecture on it recently, love addiction, and other reasons why you don't leave. Your own trauma, your own sense of helplessness. Others don't like that argument about helplessness. All of these things you have to be well informed about trauma responses when you're evaluating these cases. Because a lot of times, if there is a victim, their behavior is counterintuitive. But there is a school of thought that if a child custody evaluation has been ordered by the court, that there's necessarily abuse involved because there's some dysregulated person who's being abusive. That is not a view that is shared across the all court systems. Other evaluators do not experience that. My own feeling is you've got to be very knowledgeable about it and look for it, regardless of statistically whether it is a regular phenomenon or not. I would say that I do think that when you have these cases, there is a way of trying to get data over time. And I should say another thing about abuse, it's a pattern of behavior. One time a person blowing up and hitting somebody or mouthing off in a terrible way that's extremely hurtful to the other party or child. These are all very serious things and need to be taken very seriously, but they're not, if it's a singular act, abuse. Abuse is a pattern of behavior. You have to see it repeated over time. So I think that you do have to be very knowledgeable of trauma if you're an evaluator, of abuse dynamics. You have to also be very knowledgeable about addiction, because addiction is highly correlated with abusive dynamics. So you have, and addiction can be very hard to pick up. I mean, I don't have to, you probably know that addicts often are very deceptive about their behavior. And you have to, Neil was talking about collaterals. They are a very important source of information. The people who know and work with the family. These are often teachers and pediatricians, but sometimes neighbors and other people. You have to look through records very carefully. Academic records, medical records, criminal records, all must be reviewed to see if they unearth something that suggests a pattern of behavior. Just to go back to collateral too, I know Neil was making the point that I think your point, Neil, was that they can be viewed as hearsay. And my understanding is that as long as the collateral can be examined and cross-examined in court, they are a legitimate source of information, but you can review that in one's own work. I think that to get at this, to get at these dynamics, the evaluator has to use a technique we used back in the days of when I was working on a huge cultural anthropology study of participant observation. You have to be with the family over a period of time, so they trust you, so that they believe you are there for their own best interest. This takes time. This isn't going to happen in a few days, a week, a month. This takes time to look at. Clinical interviews are very important. What's revealed in that and how that contrasts and corroborates other information as you're picking it up. I'm wondering if I'm going over all of these. There are two they're very good trauma, what they call the trauma tip sheet, but there's getting at what's going on in the family and seeing who's doing what to whom. Many people say you need to do screenings. There's some very good, Safer's one of them, screening devices to check for domestic violence right up front. My only concern is that often victims of domestic violence and perpetrators and everybody in the family denies that it's occurring, may not believe it's occurring. They don't want to see themselves as a victim. They don't see themselves as a victim, nor does the perpetrator want to see themselves as a perpetrator. I didn't do that. So they will say, no, that never happened. Well, yeah, it did. There's a lot of denial and disassociation that goes on here until things get completely out of hand, and then you've got somebody badly hurt or even dead. So these are all things that the evaluator needs to be sensitive to. And unfortunately, still, I just heard a lecture on this, the court is highly suspect of litigants who make abuse allegations. Now, there's some very good studies on this. They're more sensitive when women make them than when men make them. But I will tell you, this is a universal phenomenon, what I'm talking about here. It happens in same-sex couples. It happens in all socioeconomic groups. It happens in all ethnicities, religions. It happens across the board. But as Neil was saying, allegations of abuse that are unsupported is looked upon very unfavorably by the court. And yet, with abuse so hard to prove, what do? Now, to get into this specific case of the Valva case, where the mother, what my understanding from, but again, this is not, I can't state this factually. I can only state it as a result of speaking with attorneys who were consulted on this case. The mother did not cooperate ultimately with the child custody evaluator because the evaluator would not allow the evaluation to be taped. This is not an unusual request. The mother wanted to tape wanted the interviews taped. At least her interview tape, and the evaluator would not permit this. Not only is this not an uncommon practice, it is a common practice to tape the interviews. There was nothing extraordinary about the mother requesting that. And that the abuse allegations were unsubstantiated gets back to this issue of abuse being so difficult to detect. Even the various child protective services in New York City and then out on Long Island and upstate New York, that are charged with doing that I know some of these folks, they're very frustrated. They know that the instance of abuse is higher than what they're detecting, but children recant. They don't say anything at all. This is despite trained medical personnel, including pediatricians, examining the case, police officers trained specially in this, mental health providers, social workers, and so forth, trained in this, they can't get at what really happened. In the Nixmari case, which was, gosh, a while back, I think in the 90s, the Child Protective Services had been at the apartment the night before, and they never saw the child. She was dead the next day. It's very hard to know, even trained people who look at this, to detect what's going on, particularly child sexual abuse. There is a statistic, 2% of child sexual abuse cases are actually founded. And we know from other evidence that it's higher than that. So that it was undetected, that the abuse was undetected, that the mother wouldn't work with a child custody evaluator, that she wouldn't work with the attorney for the child. That was another source where she did not feel supported. And she was very concerned about what she said to them. She thought the deck was stacked against her. This is what an old term we used to use, the scuttlebutt around the case was. I don't know this factually. But I know that it fits a pattern that we see where the abuse is not believed. And that appears to be what happened in this case. They couldn't detect it from the investigation. The child custody evaluation was never done because the evaluator wouldn't tape the case. He taped the interviews. And the attorney for the child was not somebody that the mother felt she could trust or work with. Certainly, I've been on many cases where you're beyond frustrated with the people in that role. They don't seem sensitive to both parties and to the issues that we're talking about here. So these are all of the dynamics of abuse that I think the evaluator needs to be aware of. But I was particularly intrigued. Neil really got spot on something. Each attorney develops a theory of the case for the court. That's really true. And the theory of the case often, when it comes to abuse allegations, is that the perpetrator is being falsely accused. There's a sense of, they're just trying to use this allegation strategically, or they're trying to get back at. There's a revenge motive here, or some other myth that accompanies all our beliefs about domestic violence and abuse. And sadly, too, this lecture was really driving home the other point, how often the courts look at race, economic level of poverty, other factors such as that in making their own assessment of the case. These biases run deep, and they can be very hard to overcome. So that's the dynamic, very broadly speaking, that the evaluator is charged with bringing to the court's attention and bringing the evidence of it to the court's attention. And so it's no small task. But abuse is so damaging to the individual. It's so that it's got to be done. So thank you.
Well, thank you, Robin, so much for that wonderful presentation. Both you and Neil can remain muted now while I proceed, and then we'll unmute when we get into our concluding remarks. So I'm going to proceed with my piece now and share with you my views about the criminal proceeding. Both Doctors Grossman and Lynch focused on family court proceedings, and I'm going to talk about these criminal trials that ensued in connection to Thomas Valva's what was ruled as a murder. So, Thomas Valva's father, Michael Valva, and his fiancée, Angela Polina, were arrested on January 17, 2020, and charged with second-degree murder and 4 counts of endangering the welfare of a child. It was noted prior to the trials that if convicted, they would face 25 years to life in prison. At the time of Thomas's death, he and his 2 brothers and Paulina's 3 girls all lived in the home. It was originally ruled by Judge Condon that Valva and Paulina would be tried together in one trial, but Valva and Paulina's lawyers argued for them to have separate trials, citing their antagonistic defenses. They both were tried separately in Suffolk County courts in Riverhead, Long Island, New York. A different judge, Judge Timothy Mazzei, presided over Paulina's trial, not Justice William Condon. There were many statements made by the judges, the prosecutors, and defense attorneys. I will recap a few going forward. Starting with Michael Valva, he was charged with murder in the second degree, a Class A felony, and 4 counts of endangering the welfare of a child, a Class A misdemeanor. A jury of 8 women and 4 men was selected for Valva's trial. John Loturco, attorney for Michael Valva, and Anthony LaPinta released the following statement. Michael Valva and our defense team are ready to proceed to jury selection and trial. We appreciate the complex challenges of jury selection considering the tragic nature surrounding the case and the extensive negative pretrial publicity. However, we're hopeful that we can select a fair and impartial jury in Suffolk County by having thoughtful, honest, and meaningful conversations and prospective jurors. The statement continued. At trial, if the jury scrutinizes the evidence without any preconceived opinions, and if they follow the law, including delivering a verdict free of emotional appeal, then we are confident that a fair and impartial jury will understand that Michael Valva did not commit the murder of his son, Thomas Valva, nor did he engage in conduct that created a grave risk of death to his son. The defense further maintained that Paulina was the one who put the boys in the freezing garage while he was at work. Suffolk Supreme Court Justice William Condon said the jury can consider whether to convict Valva of second-degree manslaughter, which is punishable by a maximum of 5 to 15 years in prison, or criminally negligent homicide, which is punishable by up to 4 years in prison. Thus, the jury was given instructions that they could go for lesser charges. The jury deliberated for 7 hours and arrived at a unanimous verdict. Michael Valva was found guilty on November 4, 2022. Prior to passing sentence, the judge commented that Thomas and his brother lived their young lives under constant duress in a place where they should have felt safest, their own home. He went on to say that we can never let this happen again. Michael Valva was sentenced to 25 years to life. Members of the jury said that the details of 8-year-old Thomas Valva's tragic death have haunted them for weeks and believe the 25 years to life sentence handed down by Judge William Condon was justified. Valva is housed at the maximum security Clinton Correctional Facility in Dannemora, New York. A notice of appeal has been filed. Moving on to Angela Polina, she was also charged with second-degree murder, Class A felony, and 4 counts of endangering the welfare of a child, a Class A misdemeanor. The jury selection process saw more than half of the 600 potential jurors dismissed because they told the court they couldn't be fair and impartial to the defendant based on their prior knowledge of the case. This was very upsetting to Polina, who didn't think she could get a fair trial. The prosecutors portrayed her as a wicked stepmother who tortured the boys out of frustration of their incontinence problems. The prosecutor said she knew something was very wrong with Thomas and she didn't do anything. That's depraved. The prosecutors also insisted that Polina and Valva acted together. Matthew Toohey, attorney for Polina, said his client is maintaining her innocence 100%. She is innocent. The goal, he said, is to find a jury who will look at the facts and not let emotion take over. It's a terrible tragedy, especially when a young boy dies, he said. People want blood. They want someone to be accountable, but she's innocent. The defense further stated that no matter what anyone might think of her behavior toward the child, she did not murder him. He said that he believed Valva thought the kids needed tough love because he, referring to Thomas, was on the spectrum. He needed a harder hand. That was a mistake there. The defense also tried to say that Polina tried to help him. The judge provided the jury a detailed explanation of the charges against Polina. The jury deliberated for 5 hours. After the jury had come to unanimous verdict, the judge came up to them and told them they reached the right conclusion. The verdict was given on March 10, 2023, and Polina was found guilty. The sentence was given on April 11, 2023. Polina was sentenced to 25 years to life in prison. The judge started off by commenting on how Polina called herself evil when talking about the treatment that young children had to endure and talking about herself. He also went on to talk about how Polina had shown absolutely no signs of remorse for the treatment she inflicted on the boys. Judge Mazzet's statement, "My only regret, Miss Polina, is they don't have a garage with no heat and no mattress and no blankets and no pillows," was dramatic and a loud expression of the repugnance in having to sit on such cases with perhaps a message that changes needed to be made when it comes to sentencing in child abuse cases. In fact, Suffolk County Presiding Officer Kevin McCaffrey released a statement saying, "Now that justice has been served and the killers of Thomas Valva have been sentenced to lengthy prison sentences, the Suffolk legislature will move forward with this investigation into the failures of the county's CPS system and begin to do all we can to ensure that every child is protected from neglect and abuse." Jurors' reactions also were harsh, as they were in Valva trial, including, as an example, "I think she's a horrible person. She told us what she did." Angela Polina is incarcerated upstate at the Bedford Hills Correctional Facility. Polina's defense attorney, Matthew Toohey, said that Polina is filing a notice of appeal. That concludes my piece, and I'd like now to open up for a discussion. So, Robin and Neil, please unmute yourselves, and any comments that you have overall. Let's look at them now.
Okay, I'm going to start. I want to follow up on something that Robin said. At first, Robin, thank you for all that information that you gave us, but I'm going to focus on one thing. The mother thought the case was stacked against her and she refused to participate. I'm going to suggest that that may be a type of paranoid thinking. But rather than labeling it, which I have, I want to go back and say that if the mother had participated more, the system may have worked. If the forensic evaluation had been done, the abuse would have been highlighted. And I'm not saying that the forensic evaluation would have picked it up in the personality testing, but in the collateral interviews, it would have picked it up, and that would have highlighted it.
Neil, I know it certainly looks that way, but my understanding, and again, these are just understandings from what was said. There's I don't know, I used it earlier, that old term scuttlebutt. I don't know if that's a familiar term. What's the scuttlebutt? What's the down and low? But it's just what's being said. It jived with my own experience on some of these cases, but so I want to make it clear, I don't know this factually.
Well, Robin, you said that the mother wasn't believed, and she wasn't believed with the sexual abuse allegations, and I don't know whether that occurred or whether it was false, but I don't think the mother was able to give voice to her concerns. Her voice, her concerns were dissipated like a cloud, and no one had the substance to deal with it. A good forensic evaluation would have picked this up.
My understanding was that the mother was just really angered everyone because she was relentless in calling for help for her children. She knew something was terribly wrong, and that Thomas was in need of special services, and so particularly sensitive to this, but that she was pleading with the court very aggressively, and with anybody who would listen to her. This was my understanding from the accounts that were in the papers, but also from what I heard from the people who were that she consulted, that the abuse was unfounded is, as we've discussed, a real problem with protective services. They do, my understanding from talking to a very senior attorney with that group who's very sensitive to this problem, was they do a very thorough investigation, at least when child sexual abuse is alleged. Now, in other words, they bring in various experts who are trained in this, but it's a one-shot deal. And abuse occurs over time. And if there's a child involved, the child, if a child is old enough to be interviewed, the child, they won't say anything. They'll deny what occurred.
Robin, let me interrupt you for a minute, because I just want to point out that child abuse allegations or child sexual abuse wasn't what killed Thomas. Child abuse, child maltreatment killed Thomas.
Well, that is certainly what caused his death, was child abuse. And the abuse, whether it was sexual abuse, it certainly was physical abuse, it went undetected. We need to have a better mechanism, in my view, for when these allegations are made. We need a better way of testing for whether abuse is in fact occurring. We're using a very unreliable system, and I don't think anybody would disagree with that. And so that it goes unfounded doesn't really tell you anything. It also, concerning the mother's lack of cooperation, it really was tragic, because it is known that evaluations are sometimes very biased. Personal accounts of this, various books, but also academic and scientific articles have pointed to this problem of the evaluators not being well trained in this, being biased and so forth, that this is a problem. I don't think it's a problem across the board, but I think it can be a problem. And so when the evaluator wouldn't, assuming this is true, wouldn't tape the interview, that set off alarm bells for the mother, and not unreasonably. There is a problem that when abuse is occurring and you go to court for protection, you find your problems have just begun. They're not going to believe you. As a matter of fact, they're going to turn against you. And this, while not universally the case, we have enough evidence to know that it happens often. We don't know how often, because data is so hard to collect on these cases, but we know that it happens. So she thought she was protecting her children when in fact that wasn't the case. But she didn't. But what she did was anger everyone. But if she had gone ahead with the evaluation, would the evaluator have done the collateral investigation, that part of it, necessary to determining whether there was abuse? A lot of times they don't. I'm just on a big case right now concerning exactly that. An evaluator who's been working
Robin, sometimes they don't, but sometimes they do. And
Right.
it's unfortunate that there wasn't a forensic evaluation in this court, in this case, to inform the court, better inform the court.
But we don't know that the evaluation would have done that.
We don't.
And that's where the mother in this instance was in a very tough spot. And it's not an unfamiliar one. Everybody needs to take these allegations more seriously, but we also just need a better way of assessing for it. Greater understanding of it and assessing for when abuse is occurring. And that's on all of us, I think. We have to be aware of that problem and try to do something about it. So I felt that the mother was in an impossible position, sort of damned if she did and damned if she didn't. And one that is not unusual. And believe me, I just 2 weeks ago, a case where the father was suicidal practically over the loss of his children in an unfair custody decision, where very educated people, these cases go so horrifically wrong. We need greater appreciation for the dynamics that are occurring.
Let me just jump in for a second and ask both of you, since both of you are the experts in family court proceedings. I'm not in any way putting myself in that same category. I've dabbled with it, for many years, but it's certainly not my forte. What I wanted to say as a general guideline, we try to do as much as we can, getting a hold of as much information as we can from as many sources as are available, using whatever methods and techniques we are comfortable with, including possibly administering tests, if that's one of the things that we as psychologists do, and in providing preliminary contacts with the attorneys, with the system that made the referral to begin with, preliminary reports. We point out perhaps limitations, things that are missing. We need this. We don't have this. It would be better if we had this. Because we don't have this, some of our findings may be somewhat suspect, because we're giving you the best information that we have, best based on everything that we have and everything that we've done. Would that be more or less a fair, short summary of a process, like a general guideline for evaluators?
That's aspirational, and we should be informing the court on the strengths and weaknesses of our evaluations.
Okay.
Yeah.
I'd like to make Robin, unless you have any more comments, I'd like to make a few personal comments about the criminal proceeding based on my long history of having done a lot of work in criminal cases. I wanted to share that. Robin, anything else, or I can go forward with my own observations?
No, Roy, please go ahead. Go ahead.
In retrospect, I really think that Michael and Angela, that they made a big mistake in pushing for separate trials. I think that what happened as a result of it is that each one was throwing the other under the bus, trying to portray the other one as the evil, wicked mastermind of the injuries to Thomas, and minimizing or exculpating as much as possible his or her role in what happened. So that basically you had dueling defendants, and jurors, prosecutors, defense attorneys, the judge, they're all hearing these remarks. And a lot of it, of course, was portrayed in the news media. Had they not severed, had they continued together, they would have presented a unified front. Chances are it would have been heard by the one judge, by Judge Condon. Not that Judge Mazet did anything incorrect or improper at all, but it involved another jury selection. It involved passage of time. Angela, as a result of the passage of time going second, had everybody already knew what happened. They already knew what the results, what the outcome was of the Michael Valva trial. They knew that the lesser charges were ignored by the jury, and they went ahead with going for the maximum, which led to the 25 years. I think that they would have done better. And of course, you saw that with the jury selection. She complained that half of the jurors were saying that they were already in some way prejudiced against her because of what they had heard and what they knew in the case. So her going after the fact already put her in the situation that she is now trying to put him under the bus further, throwing him under the bus. Well, you got convicted. I'm totally innocent. You're convicted. You got the 25 years. I'm fine now. But the problem is that all of her behavior was highlighted. So it's really my personal opinion. Okay, there's no way we'll ever know. But I think that probably going together, the judge again might have offered the lesser charges, and maybe that they could have dovetailed or carved out something, or maybe even arrived at a plea agreement for the lesser charge. Some of that would have been possible in foregoing a jury trial altogether. I tend to agree that the outcome was fine, was what they deserved. I'm just talking about just from a legal perspective, from what some of the legal proceedings and mechanisms are in terms of what might have made more sense to them from a defense standpoint rather than the way they proceeded. It's really too late now. Obviously, I have absolutely no idea what any sort of a basis for an appeal would be. I just don't see it. I don't see it. The appeal has to be based on the trial, has to be based on what took place. You cannot introduce new information into the appeal. You cannot retry it in the appeal. So the appeal has to be based on the record that was established. And I'm really puzzled over what on earth they would do to try to move forward with an appeal. So that's my quick summary.
Thank
Roy?
you for presenting alternate views.
Yeah, yeah, exactly. Roy, and this is just a question because I'm not sure it applies in a case like this at all. Could the mother, in this instance, she is appealing her conviction. under the Domestic Violence Justice
You mean the in quotes stepmother?
stepmother, pardon me.
Okay.
Sorry.
She's not even a real stepmother.
Yeah.
Okay.
Yeah. The Domestic Violence Justice Survivors Act, which allows sentencing guidelines to be modified in light of context, the context of the case. So if but I think that just applies to the perpetrator. I think, in other words, as I understand it, the essence of that law is that it is applied to victims who are themselves a victim of domestic violence, and then when they lash out and react and someone gets hurt, the judge is allowed, if he wants to apply the law, he or she wants to apply the law, to suspend the sentencing guidelines. I'm not saying that very, very well, but I don't even think it applies in a case like this.
Well, they've already been sentenced, so that the appeal has to be based on the case that was presented, and it has to be based on the transcript. Like I said, you can't add anything new. You can't bring a new witness. You can't retry it. There has to be a basis. There would have to be something as a hypothetical along the lines that the judge made many rulings that were in favor of the prosecution, and ignored rulings that ignored objections that were made by the defense attorneys, so that, to some extent, the judge saying, objection overruled, objection overruled, objection overruled, objection overruled. Every time a defense attorney made an objection, that possibly could be appealable if it shows a pattern. So it has to be based on the transcript, on what took place in the trial. You cannot invent or add anything new. So I'm curious to know what it is. In the matter of Michael, I mean, the trial is already over a year ago. So by now, I'm wondering really what's been developed at all. I couldn't find anything. I couldn't find anything that explains anything more specific about his basis for the appeal. Obviously, her conviction was far more recent, and I haven't found anything there either. So it'll be interesting to see what comes up down the road, and if even it would be their attorneys right now who would go forward with the appeal. I mean, there's nothing saying it has to be them. They could basically go to other attorneys, or attorneys may pop up and ask them, "Do you want to retain us as as an attorney for an appeal?" And then, of course, there's the issue of how they're going to get paid. People work and they want to get paid. Attorneys would like to get paid for their work. I'm not sure anybody's going to want to do this pro bono. So at any rate, I don't want to leave Natsalin out of the mix here. Okay, you're an advanced student at John Jay College of Criminal Justice, Forensic Psychology. I know we've focused many occasions in class and in other discussions on criminal proceedings. So why don't you, whatever take you have of everything that we covered, I'd like to hear from you as well.
Thank you, Dr. Aranda. I really appreciate that. I feel that based on the conversation today, it was very well-rounded. I really appreciated the brief background and description as to the actual court proceedings that Dr. Grossman described, and then Dr. Lynch, just the specifics as to family dynamics and how they might be perceived during certain court trials or proceedings, specifically in this case, unfortunate case where it resulted in the death of Miss Young Valva. I felt like it just really put everything into perspective, as well as Dr. Aranda, just your opinion based on the case as well kind of gave a different take as to how we can perceive what happened and the things or the next steps that could ensue after the decisions have been made. So I really don't have anything else to add, honestly. I think it was very informative overall, and I'm just grateful to be here and to help out in any way that I can. Thank
Well,
you.
thank you, and I'm grateful to have your assistance. I'd like to share with the viewers that we all were very touched by this. I live in Suffolk County, and so does Neil. And we this was like in our backyard, and I remember following this very closely from the beginning, and my heart really went out to that little boy. I mean, I had tears in my eyes when I heard that he had died, and I saw the beautiful photo, the photo of this beautiful little boy on the spectrum, and I just couldn't imagine how people could be so heartless and insensitive and just not uncaring to go forward and treat him and abuse him the way they did. I also have to wonder, about the other. There were other siblings, and Paulina had daughters. What sort of exposure did they have? How are they traumatized after the fact of what happened? And hopefully, all of the many systems that were in place and failures that they had, hopefully there's a wonderful effort, or much better effort, hopefully. Maybe I'm reaching out too much, but a better effort to really try to correct these types of mistakes so that this doesn't happen. Prior to ending, I did want to offer our presenters, to let our viewers know how they can be reached if viewers have additional comments. So, Dr. Grossman, Neil, is there a way that you would like the viewers to reach you?
Yes. If anyone has a question or comments, you can reach me by email, Dr. Neil, DRNEIL, one word, at mindspring.com, one word, MINDSPRING.com.
Okay, why don't you repeat it one more time? I love repetition.
Dr. Neil at mindspring.com.
All right, thank you, Neil. Robin, how would you like viewers to reach you if they have additional comments or questions for you?
Email is best. Like Neil, email is best. rrlynch@aol.com. rrlynch@aol.com.
Thank you. Viewers who would like to reach me can do so by telephone. My main office is area code 718-457-3715. You also can reach me by email at braindocr@aol.com. I'm a neuropsychologist, also a forensic and neuropsychologist. So I became brain doc, but I realized somebody had it, so I had to take brain doc R. So that's BRAIN, like a human brain, DOC as in Charles, R my initial, at AOL.com. Now, that concludes our presentation. I'd like to thank our speakers, Dr. Neil Grossman and Dr. Robin Lynch. I'd like to once again thank Natslyn Peralta as well for her assistance. And to the viewers, thank you for watching this presentation. We look forward to any comments that you may have. And going forward, that is a wrap. Thank you very much.
Thank you.
Thank you.